So let's start.
Hello, everyone. You are here at the Energy Charter Treaty Disputes webinar organized by the Ukrainian Arbitration Association and the Stockholm Chamber of Commerce Arbitration Institute, the SCC. Let me begin by introducing our panel members. After that, I will describe how we are going to organize this panel, and after that, I will pass the floor to the speakers. Let me start with Olga Hamama, a partner at V29 Legal, a newly established German arbitration boutique. Prior to co-founding the boutique, Olga was a member of the international arbitration group with Freshfields. Noah Rubens, the head of International Arbitration Group at Freshfields in Paris. Noah heads Freshfields Russia CIS Global Dispute Resolution Practice Group and is also a US and English qualified Russian-speaking lawyer who represented clients in nearly 100 arbitrations. Olena Perepelinska, a partner at the Ukrainian law firm Integritas. In addition to being the president of the Ukrainian Arbitration Association, Olena acts as a board member of several important professional organizations and is also listed as an arbitrator in dozens of arbitration centers and institutions. Olena is one of the top female lawyers in Ukraine. Last but not least, Markian Maski, a partner at Arzinger, specializing in investment projects, as well as international commercial and investment arbitration. Markian heads the Western Ukrainian branch of the firm and the international dispute resolution practice. And Markian also holds a PhD degree in law and is also an alumni of the master course at the Stockholm University. And I am Natalia Petrik, legal counsel from the Stockholm Chamber of Commerce Arbitration Institute. The institute was the first organization to administer an arbitral proceeding, which resulted in the first Energy Charter Treaty-based award in 2003. And since then, 30 arbitral proceedings with Energy Charter Treaty-based claims have been handled under the SCC arbitration rules, along with dozens and dozens of claims based on bilateral investment treaties. So what will we be discussing at this seminar today? Olga Hamama will start by sharing some general information about the SCT and touching upon an interesting and not entirely uncomplicated question of its scope. Noah will be talking about jurisdiction of arbitral tribunals over SCT-based claims, and Olena will touch upon problems and trends in the current and potential treaty claims in Ukraine. Markian will deal with enforcement of treaty-based awards in Ukraine. And I will be moderating this session. I will leave around 15 minutes at the end for the questions from the audience. And we would really encourage you to participate by including your questions into the chat. I don't think I have more administrative matters, and I am passing the floor to Olga. And my question to you, Olga, will you give us an outline of the purpose and current status of the Energy Charter Treaty, and also answer to a yet more interesting question of what an energy dispute actually is from the Energy Charter Treaty perspective?
Thank you very much, Natalia. Thank you very much for the kind introduction. Also for the invitation. It's a great honor to be an opening act and to pave the floor from my esteemed colleagues that are going to follow. So what I would do, I would briefly provide, map the background of the ECT and share the insights where it stands now and also where the so-called modernization process is going. And then we'll indeed address the topic of energy disputes and what does this mean in the context of the treaty. So starting from the very beginning. Looking into the history of the treaty. As many of you know, treaty dates back to 1994. It was signed in 1994 and it was adopted in 1998. But the idea of the treaty dates back to 1990 and was negotiated in the context of the end of the Cold War. So the initial process was began in Europe, and was aiming at providing a stable framework between Western and Eastern European countries. So on the one side, Western countries were interested in securing a stable energy flow from the Eastern European countries, which were, and Central Asian countries, which were rich in fossil fuels and natural resources, and on the other hand, provide a safe network for investments from Western European countries to Eastern European countries to promote and develop energy sectors. So now we are looking back at a time span of 22 years. The purpose of the convention is of the Charter Treaty is defined in Article 2 of the treaty. I would briefly read it out. So the purpose has been defined as follows. The treaty establishes a legal framework in order to promote long-term cooperation in the energy field based on complementarities and mutual benefits in accordance with the objectives and principles of the Charter. So at the time, it was a unique multilateral treaty because it concentrated on one specific sector, energy sector. Among others, the treaty comprised various parts. Part 3 of the treaty addressed protection and promotion of investments and granted rights to investors. And most importantly, also in the context of our discussion, part 5 of the ECT provided for dispute resolution mechanisms, specifically for state-to-state dispute resolution mechanisms in Article 27. And Article 26 provides for investor-state dispute resolution mechanisms. So specifically to enforce their rights, investors can turn first to a cooling off period of 3 months is provided for to encourage amicable settlement of disputes. And then Article 26 also provides various forums for investors' choice, including national courts, previously agreed dispute settlement procedures or treaty arbitration, and ECT investment arbitration, ad hoc investment arbitration under UNCITRAL rules, as well as investment arbitration administered by the Stockholm Chamber of Commerce. So having briefly mapped out this key point, I would like to briefly discuss with you where do we stand now, again, like having, looking back at these 22 years of its existence. So by now, the treaty has been ratified by 53 countries, the European Union and Euratom. As of 9th of October 2020, Secretariat reported to be aware of 134 investment arbitration cases instituted under the Energy Charter Treaty. Again, just a brief caveat, there is no obligation of the parties to report any disputes to the Secretariat. That's why this number might be actually bigger. So what happened in the course of these years? As many of you know, in July 29, Russia gave notice that it was withdrawing from the treaty. So at the beginning, it signed the treaty, but didn't ratify it. However, it accepted provisional application of the treaty, which has been then withdrawn. Also in 2015, Italy notified that it was notified the Secretariat, apologies, that it was withdrawing from the treaty. Also, many other states joined the treaty in the meanwhile, which are not necessarily related to the so-called primary geographical area of the treaty, which are not located in Europe. Such states as Japan or Australia, for example, signed from the very beginning, but we've seen many developing states such as Yemen or Afghanistan joining this treaty in the meanwhile. What happened after Russia's withdrawal from the treaty? So first and foremost, keeping in mind the initial purpose of the treaty, it seemed like, Russia, who was the biggest provider of fossil fuels from the, former Soviet Union bloc, was not a member and part of the treaty anymore. The so-called modernization process has been actually initiated immediately after Russia's withdrawal. So obviously it took a very long time, and it's still, pending, but it was envisaged actually to be completed in 2020. However, it looks like it will take longer than 2020 for various reasons. So looking maybe also briefly at the cases, at the number of cases. So I mentioned that there are 134 cases which the Secretariat is aware of. Out of those cases, most of the cases, almost 90, relate to intra-EU or EU-related investment arbitration proceedings, where either respondent state or investor is seated in a member state of the European Union. Most of the disputes, like almost 75%, relate to the electricity supply and connected deals. Solar sector takes up for more than 70% of disputes, while, for example, fossil fuels are addressed in approximately 17%, like almost 20% of disputes. Then there is a small share of nuclear disputes and other alternative energy sources. What is happening in terms of modernization process? Where are we, and what are the main driving forces at the moment, or the most critical point for discussions behind this modernization process? So obviously there are a lot of different aspects which are addressed and on the agenda, and it has been already a lengthy process, and it's not necessarily likely that there will be progresses in many respects, because to change provisions, also anonymous voting in favor of a change is required from the member states. So just to name a few critical aspects. So one of them obviously being made in the context of the low carbon transition. So especially from the European side, and within the from the members of the European Union and European Parliament, the pressure is coming to include provisions which would envisage phasing out of fossil fuels, which would encourage investments into renewable energies to promote low carbon transition. And in this context, there is also a suggestion to explicitly include the right of the state to regulate in this context, which doesn't mean that this right has not been claimed or enforced in the pending decisions up till now. There is obviously also a discussion going on with regards to SDS, especially within the European Union, in view of the ICMEA decision and European Commission's argument and member states' argument that intra-EU BATs are not compatible with the European law. This is just to name, a couple of main topics which are in the discussion, and we will see how it's going to end. Again, the pressure is rising on the European Commission and European Union to push for, adoption of new provision which would enhance and enable low carbon transition. At the same time, as a worst case scenario, European Commission is not excluding the fact that it would withdraw from the treaty. However, it's not its priority because it prefers to make the effort to amend those transitions, because, as you know, in view of the sunset clause, if the EU and its member states were to withdraw from the ECT, the provisions would still be applicable for the next 20 years. So this is just to map the process where we stand now. I'm excited how this process is going to develop and end at the end. So now coming to the second question, to the scope of the treaty, and in particular to the question how energy disputes are defined within the ECT. Talking about the ECT in general, it's important to know that it's a very complex treaty, and it's been already defined as an untidy and user-unfriendly document. It consists of 8 parts, 50 articles, 14 annexes, 5 decisions, 22 understandings, 8 declarations, and we will see that all those bits play together when looking for an answer, for example, what an energy dispute is. So in general, the scope of the ECT is very broad. The ECT addresses and covers various areas in the energy sector, starting with trade, promotion and protection of investments, transit in the energy sector, environmental protection and efficiency, and settlement of disputes. So if we would like to talk about the scope and investment under the ECT, it's important to have a look at Article 1, which provides definition for many terms and legal notions which are relevant in this context. The notion of investment is defined in Article 1.6 of the ECT, and it's also quite a broad definition comprising every kind of assets, owners, or which are owned, controlled directly or indirectly by an investor. But as one of the requirements, it also states that such an investment has to be connected, associated is the original language of the ECT, with an economic activity in the energy sector. And this is where, it becomes also a bit complicated, and we have a lot of information or definitions in the treaty with this regard. What is important to understand, again, looking into Article 1 of the ECT, Article 1.5 of the ECT defines the economic activity in the energy sector. The definition reads, it's an economic activity concerning the exploration, extraction, refining, production, storage, land transport, transmission, distribution, trade, marketing, or sale of energy materials and products, except those included in annexes. And in this context, again, it's first of all is important to look at these accompanying annexes and understandings. So understanding number 2, for example, clarifies what is meant by the economic activity in the energy sector. So I would advise everyone to have a closer look at those definitions. Also, it is important to mention in this context annexes of the treaty, especially annexes EM1 and 2 and EQ1 and 2, that provide definitions of covered energy products and materials, referred to as energy materials and products, and energy-related equipment. So these lists are very lengthy. I'm not going to bore you with reading out just to give you an example. There are more than 90 products with various subcategories named in those annexes. So as we experience in practice, such detailed definitions can be helpful, but at the same time, there is still, we've seen a couple of disputes where this specific issue was at the core of the dispute. And so just to name an example, and since this panel is also co-organized by the Ukrainian Arbitration Association, I would like to briefly, to conclude my presentation, to briefly mention the Amter versus Ukraine case, which arose out of bankruptcy proceedings of the Zaporozhskaya nuclear power plant. And in this specific context, the tribunal was, tasked with the question whether activities, such activities as, for example, maintenance of the power plant, which was accompanying the construction, would also can also be defined as an energy related activity under the ECT. So just to give you a precise answer of the tribunal, briefly, I would like to read out the last passage of their decision. The tribunal decided that in the present case, Energoatom is engaged in an economic activity in the energy sector, as its activity concerns production of energy material and products, namely electrical energy. The company, the claimant, also provided technical services such as installation, reparation, upgrades directly related to the production of electrical energy through various contracts which were related to construction and maintenance of the power plant. So having looked at various arguments provided by the parties, the arbitral tribunal decided at the end that since these activities were closely connected with the, again, construction and maintenance of the nuclear power plant, and there were multiple contracts which were directly concluded in this context between the parties, that this activity, although not specifically listed in the Energy Charter Treaty, amounted to activity associated with energy sector and was covered by the ECT. So that much from my side. Maybe at the beginning, I'm happy to answer any questions afterwards. Oh, no.
Thank you, Olga. That's very interesting. And obviously, despite the city's broad scope of protection, there are much more requirements for a claim to be protected. And I'm passing the floor to Noah. Noah, will you enlighten us on who is protected and which investments are protected? And another question, whether restructuring of investments may help an investor to obtain protections under the SCT.
Thank you so much, Natalia. Of course, these questions could take an entire day or a week. As Olga quite rightly said, the Energy Charter is an extremely complicated document, both in absolute terms and also when you compare this treaty to the vast majority of investment protection treaties around the world. That's natural, given that it is a multilateral document that was negotiated between a large number of countries. As some say, a camel is a horse by committee. And one could say that some of the quirks of the Energy Charter Treaty must be the result of compromise. Now, what I would like to do is give just two examples of how the Energy Charter Treaty is special and especially tricky, even in the most basic questions of what is protected and who is protected. We start from the same point as you start when looking at any investment treaty, and that is, what are the definitions for what is protected and who is protected? That is to say, who has standing to sue about what? And in the treaty, we've already seen one of those definitions, and I'm going to show to you now so that we can look at together. Can you see my screen? Have I done it correctly? Can you see the text of the treaty? Natalia?
Yes, we can. Yes, we can see
Super.
it.
Okay, great. So with respect to what is protected, we've already heard from Olga about Article 1.6, which is the definition of investment. Now, here it's extremely broad, as is said. Investment means every kind of asset owned and controlled directly or indirectly by an investor. Now, note here that it says owned or controlled. We'll come back to that in a minute because that's particularly broad. Very often you'll see in some treaties reference to investments being made. Investments being made. Here you don't see that, right? At least not in the definition. And when we look to the definition of investor, which is down here, we also don't see anything that says, for example, an investor has to make an investment. But we'll come on to other definitions that make it a little bit more complicated than that. So we have here, as I said, investment is any kind of asset, and then there's a non-exhaustive list, which seems to include just about everything, every kind of asset, right? And it includes, for example, under C, claims to money and claims to performance, right? Which is just about any kind of economic activity you can imagine. Of course, it is limited down at the bottom, as we saw, to those investments which are in the that are associated with an economic activity in the energy sector. Now, here's the tricky bit. There have been a number of cases recently, not under the Energy Charter Treaty, but under other investment treaties, saying that an investment is not an investment unless it is made. Just having something isn't enough. There has to be some kind of direction, action, some kind of active participation in economic activity, and not just the passive sort of sitting and holding it. Now, that's an important point because particularly in relation to energy investments, very often energy investments are structured in an extremely complicated way with many holding companies, and that's often necessary in order to engage in project finance, and it's been recognized as being, in most cases, perfectly legitimate. But in cases like Standard Chartered against Tanzania and KT Asia against Kazakhstan, tribunals have said it is either inherent in the word investment or it's suggested by the words made. Like an investor is someone who makes an investment, or an investment is an investment made, right? That there has to be some kind of activity. So now the question has never really been posed, so far as I know, in relation to the Energy Charter Treaty. And to my mind, your first port of call is to look at these definitions, and you don't see any kind of reference to making investments. It's only to having them. For example, it's an asset owned or controlled, not brought or sold or acquired or used or anything like that. There's no action verb here, right? And if you go down to investor, it doesn't refer to that person having to do anything in particular. However, there is down here at Article 1.8, this odd phrase, which I have not seen anywhere in another investment treaty, a definition for make investments. Make investments or making of investments means establishing new investments, acquiring all or part of existing investments, or moving into different fields of investment activity. And you say, well, goodness gracious, well, what's that for? It's not obviously related to the definition of investment. It's not obviously related to the definition of investor. Well, it must be for something. So far as I can see, there's only one place where this phrase make investments is referred to, and that's here in Article 10. And if you look in Article 10.1, now Article 10 is part of the substantive protections of the treaty. And in fact, Article 10.1 of the Energy Charter contains basically all of the substantive protections in the treaty, except for expropriation, which is separate, and some bits and bobs like freedom of transfer and that sort of thing. But fair and equitable treatment, full protection and security, the umbrella clause are all right here in this clause 10.1. And when we look at 10.1, it says each contracting party shall, in accordance with the provisions of this treaty, encourage and create stable, equitable, favorable, and transparent conditions for investors of other contracting parties to make investments in its area. Well, there's that definition there, which does sort of imply some kind of action, right? And then it goes on to talk about such conditions shall include. So everything that comes afterwards is subsumed within treatment with respect to making investments. It raises the question, which no one has yet answered, whether the Standard Chartered Tanzania reasoning applies also to the Energy Charter Treaty, and whether a holding company, which has been popped into the middle of a structure for whatever reason, and is the claimant in an arbitration, didn't acquire for value, for example, because it was part of an internal restructuring, whether that investment is an investment as such that's protected by the treaty. That's the first point I wanted to raise to you. Here's an even trickier one. Who's an investor? Well, we had up here in our definitions, who's an investor is in 1.7. And here we're going to ignore natural persons. So someone is an investor with respect to a contracting party. Let's take, the United Kingdom. So a UK investor is a company or other organization organized in accordance with the law applicable to that contracting party. So quite simply, a UK investor is a UK company. Or otherwise, you could do it backwards. Any UK company is a UK investor and therefore has standing under the treaty. Well, what about a local company, let's say in Ukraine, that's 100% owned by a UK investor? Well, you'd say, looking at this, no way. That's not an investor of another contracting party. That's an investor of Ukraine, right? But wait a minute. If we now go to the dispute resolution provisions of the treaty, we see something very odd. We start with, coming back up to the top, it starts as you would expect, disputes between a contracting party, Ukraine in our example, and an investor of another contracting party, the United Kingdom, relating to an investment of the latter in the area of the former, in other words, relating to a UK investment in Ukraine, which concern breach of obligations under the treaty, should be settled amicably. If not, it goes to arbitration, right? But if we look at 26.7, there's this strange language which says that an investor that is not that is a corporate person of the host state, which is controlled by investors of another contracting state, it says, shall for the purposes of Article 25.2b of the ICSID Convention be treated as a national of another contracting state. In other words, it'll be treated as a foreigner. And shall for the purposes of Article 1.6 of the Additional Facility Rules be treated as a national of another state. Now, the obvious purpose of that is to satisfy the diversity requirement of the ICSID Convention. If you're in ICSID arbitration, no matter what your treaty says, ICSID arbitration is possible only between investors and states of different nationality. There's an absolute rule with one exception. If the parties have agreed that a local company controlled by a foreign company should be treated as if it was foreign, then it is, and it's okay under the ICSID Convention, right? But that doesn't change the definitions of the consent document, in this case, the Energy Charter Treaty. And the question is, what's the purpose of this? Because after all, we saw in the definitions of the treaty that only a UK company can be a UK investor. And a Ukrainian company controlled by UK investors cannot be, under Article 1, an investor. Now, you would think this must have been worked out pretty easily, right? Wrong. In fact, it's almost never been discussed. And there have been a number of cases, including against Spain, but against other countries, where foreign-controlled local companies have been permitted to advance claims against their own state pursuant to Article 26.7 of the Convention. Now, other cases have said it's obviously not for that purpose. And a locally incorporated foreign-controlled company cannot possibly be an investor regardless of what Article 26.7 says. Now, I put to you that this is a mistake in the charter. It is one that stands as it is. We have to interpret it for what it is. And frankly, unless it actually does operate to allow foreign-controlled local companies to sue, it serves absolutely no purpose. And therefore, that must be what it does. That's what I say. But at the same time, it creates a very strange situation. If you were to bring the exact same claim, UK-controlled Ukrainian company against Ukraine under the Stockholm rules, you would be booted out, because this obviously has nothing to do with arbitration under the Stockholm rules, only under the ECT rules. So these are just two examples of how the Energy Charter Treaty, while it is an incredible document, I don't mean to demean it in any way, it is the single treaty most used in history for investment treaty arbitrations, the single most used treaty by a long shot. NAFTA is probably next, and that's well under 100 cases. Right? But there remain a lot of questions to be answered about the way it's supposed to work. The devil is in the details, and I'll stop my comments there.
Thank you very much, Noor. That's very interesting, very insightful. I agree with everyone. Energy Charter Treaty is a document you can talk about, days and days. But let's turn to Ukraine. Olena, would you like to share your thoughts and experiences about the claims related to Ukraine from the perspective of Ukrainian business?
Thank you, Natalia. Indeed, I think due to the recent developments in Ukraine, and especially in renewable energy sector, so this treaty is of particularly interest for many foreign investors and even Ukrainian investors. However, historically, if we start from the outset, Ukraine ratified this treaty back in, 22 years ago, back in 1998. And during these 22 years, there are at least 4 reported cases where Ukraine was a respondent under the ECT disputes. And as a respondent, it was relatively successful. So the first case was the case mentioned by Olga. It was Amter against Ukraine, and Ukraine prevailed in that case. Other cases were, so 2 cases, in 2 cases there were awards against Ukraine, but the amount of the award was like 10% or less of the initial claims. And those cases are Remington Worldwide Limited against Ukraine and JKX and others against Ukraine. So both cases are very interesting in many, many aspects. So Remington Worldwide Limited, I think this was the first ECT case in Russian language. This case had a very interesting story and developments in several jurisdictions. Then JKX case, again, it was initiated as 3 separate proceedings, parallel proceedings under SCC rules in ECT, and also as ad hoc under Untitled arbitration rules. And in Stockholm, the claimants even obtained the emergency arbitration award, and that award was further close to be enforced in Ukraine and I think Markian will tell us a bit more about this. I will not stop here. But then those three proceedings were consolidated in one, and the case proceeded under unsettled arbitration rules. And the last case, according to publicly available information, it is still pending in Stockholm. And that case is Litop Enterprises Limited, Bridgemont Ventures Limited, and Border Management Limited against Ukraine. This case probably is the biggest one in terms of the amount sought by the claimants, and reportedly this amount is over $5 billion. And again, according to various information, the award is expected not earlier than in the end of this year. In addition to these cases where Ukraine was a respondent, there are at least 2 reported cases where Ukrainian companies were claimants. And those cases were both against Moldova. They both were related to debts under various electricity contracts with some assignments and this difficult history again. And the claimants in those cases were had different range of success. So in the first case, Energorynak against Moldova, that case was considered in Stockholm under SEC rules, and the investor lost this case on jurisdictional grounds. However, this case further found some continuation in Ukrainian jurisdiction because the award and jurisdiction contained decision on costs, and the costs were to be borne by both parties in equal shares. And Energorynak is trying to recognize and enforce this award in part of courts before Ukrainian courts now. Another case, Energoalliance against Moldova. There was a split, so majority decided in favor of the claimant, while the presiding arbitrator dissented and said that there was no jurisdiction. Again, this case had a difficult or complicated history because the award was then challenged before French courts, and the first instance Paris. First instance court in Paris set the award aside. The Court of Appeal quashed this decision and sent it back to the Paris Court of Appeal. I think they did the right name of the court. And as I understand, the case is still there. That is what we have, at least what is publicly available. However, in recent months, there is a rising appetite to apply ECT for another set of claims, and this interest is inspired by several crises in Ukraine related to renewable center. And in just a few words to give a background, so Ukraine adopted quite generous feed-in tariff in order to decrease its dependence from Russian gas and for various other reasons. However, this very good, in essence, idea was not implemented in a proper way because of lack of strategy and lack of other considerations. And the result was that there was a boom in Ukraine, and a lot of new solar and wind power plants were established and are still under construction. Last year, Ukraine launched an electricity market. It also created a special entity, guaranteed buyer, and this entity is a state entity in charge for buying the electricity from RES producers. However, this buyer lacks funds in order to buy the energy, and this led to a crisis, and the government tried to negotiate this situation and to cut the tariff. So various schemes were discussed, and This year, this summer, Ukraine saw a very unusual development because investors came to an agreement with the state and signed a memorandum how to resolve this situation and agreed how to cut the feed-in tariff in a proper way. However, not the whole market, not the entire market participated in this process. Then, after the memorandum, the law was passed by the parliament, and it provided cut of feed-in tariff and other provisions. However, the scheme agreed with the investors also provided that this guarantee buyer would at least settle the debt, which already amounted to many millions of dollars before the investors. And I think this was the key point. The law entered into force in August, just a few months ago. And it became clear that the scheme does not work because the guaranteed buyer still lacks funds. And due to peculiarities of Ukrainian regulation, this guarantee buyers was not even able to attract some financing, and only in November, just a few days ago, the Ukrainian parliament passed a law allowing the Ukrainian government to give guarantee in order to ensure such borrowings by the guaranteed buyers, but this law is yet to be signed by the president, so it's not yet effective. In any case, the cuts of feed-in tariff already provoked some dissatisfaction among the investors, and solar and wind investors are in different situation because solar investors suffered more, and again, depending on the start of the project, the costs are different, and that is why the damages and potential losses are different. But many investors started to look at various options how to protect their investments, taking into account different developments in Ukrainian legislation. And one of the more obvious options was to initiate investment treaty arbitration. And the first treaty to look into, taking into account what this energy dispute is, was ECT. In addition, it's interesting that if we look at the structuring of the investment in this area, there are some projects structured through entities based in Cyprus. As Ukraine does not have any BIT with Cyprus, ECT is in fact the only investment treaty allowing Cyprus investors to sue Ukraine. And this aspect actually made ECT even more attractive, irrespective of the situation with RES producers, because given the lack of the BIT with Cyprus, the broad notion of energy disputes, so this treaty is often looked into and as an option to pursue some investment claims. In any case, last week, the deputy of Minister of Justice in one of the conference revealed information that there have been already about 10 trigger letters in the field. Some of them have been already withdrawn, but this is obviously the sign of potential prospects of future disputes under ECT. And depending on further developments in Ukraine, I am sure that in the very nearest future, like the beginning of the next year, we will see how the situation would develop and whether these cases would proceed to actual arbitration under ECT. So I think this is all I wanted to say. If our participants would have any questions, I would be happy to answer. Thank you.
Many thanks, Olena. That's really interesting to know about all the developments on the Ukrainian market. We will see how the situation will develop in the nearest future. And now turning to Markian, and the question is, what to do with an arbitral award? How difficult it is to enforce an arbitral award against a state particularly in the context of Ukraine, for instance, what are the main obstacles and difficulties and how you see the situation?
Thank you, Natalia. Dear colleagues, it's a great pleasure to be with you. I'm very happy we are not speaking about the influence of COVID on the economy rather than on something different, but I'm hopeful that you are all in good health and in good condition. As Natalia mentioned, I have a particular relation to Stockholm. Stockholm University flag is on my table for many years already, and I have indeed pursued an LLM degree there in international commercial arbitration. Interesting enough, my LLM degree master thesis was devoted to enforcement of foreign arbitral awards in Ukraine. At that time, we had a special law which was cancelled 2 weeks before I was supposed to submit the master thesis. So I had to rewrite a big part of my master thesis, which already speaks about the level how it is predictable to enforce an award from time to time. But jokes aside, I think to a greater extent, Ukraine has moved forward in terms of enforcing foreign arbitral awards. One of the reasons is that basically some 10 years ago, I have written this book on enforcing arbitral awards. And a year ago, I have written this book on enforcing both awards and court judgments. And truth being told, my first book from 10 years ago was a much bigger trailer and was indeed a more cowboy movie on enforcing awards rather than the last book. So I would say that to a certain extent, the guerrilla tactics are much less used. We are not speaking here about the enforcement about state against the state, but rather in private matters. But I would say that in the last 10 years, the courts have become much more professional in terms of enforcing foreign arbitral awards and court judgments. And we have indeed made a huge step forward. If we are also speaking about enforcing regular court judgments, state court judgments in Ukraine, we are now having a much more progressive approach where the so-called reciprocity is assumed. And we have a situation that basically, in case there is no agreement between the other country, the reciprocity will be assumed and the court judgment will be enforced. So I think in the 10 or 15 years, much has changed, and it is great to say that also the number of awards enforced has increased. If we are speaking about the state level, Ukraine is rather on a good count in terms of enforcing the awards. So we have seen a number of awards being voluntarily enforced, and here under voluntarily, I normally mean that the application for enforcement has been made by the interested party. And to a certain extent, there existed problems previously with regard to voluntarily execution of the enforcement of the award if there was no application. But now in private matters, this is easier, but still in enforcement against governmental agencies, against the state, the sovereign, there would have to be normally an application. We have also seen something quite new being amicable settlements in the investor treaty cases. There have been a few. I think lawyers would like to see more of them, but still the existence of a few already is a good sign. Although then later on we've heard about also some criminal investigations whether the state had the right to cite the amicable treatment agreement, and also to some other proceedings have taken place. But there is, a big truth in that amicable resolutions are also quite good mechanisms in terms of sovereigns. Now, Noah has brought very interesting ideas about the criticism of the ECT, and I would say that indeed it's a unique treaty. And surprisingly enough, when I was preparing more and more for today's meeting, I came up to a number of websites which provide much more criticism to the treaty, as we've heard today. And surprisingly for me, I've read some of the ideas, some I would agree with, some rather not, but I would say that they are both pro and cons of the treaty, and is as an idea which I would support, where Elena mentioned that this is the only investor treaty which allows the investors from Cyprus, where you, as many of you may know, the majority of Ukrainian investors come from, and simply structured through this jurisdiction.
has opened the door for protection of those investments structured through Cyprus. And as Noah mentioned, in a way that the holding simply exists and you simply hold the asset, this already has opened the door for many claims. And also, I think the treaty is very much unique in terms of the provisional application. In the case of UCOS, which I guess hasn't been mentioned today, I'm the last speaker, so I'm picking bits and pieces what is left on the table. It hasn't been mentioned. The UCOS case was exactly brought under the provisional application, and Russia, I think, probably had you know, shot itself in the foot many times, having realized that although not ratified, the provisional application of the arbitration agreement has come into place. So I think this was a very important thing. And of course, if we are speaking about further enforcement, I do believe that at least a few cases also in what Olena mentioned with regard to the green tariff will probably make it to arbitration, because we've seen a number of notices, but so far none of them really went to arbitration. But I believe we will have at least a few, because there are indeed investors who have lost some money in the projects, the green projects in Ukraine. Now, with one of the most interesting cases, which have also not been yet discussed today, is the JKX Oil and Gas and Others versus Ukraine. Now, this was a case with the Stockholm Chamber of Commerce, and the emergency award against Ukraine was rendered in this case. And surprisingly enough, there has been a full round of submissions and court decisions, and the case was considered actually for 3 years. So basically, you can see how an emergency award can be effectively enforced. But there, I would say, are also a big number of questions, and I will briefly describe the case for those of you who are not so well aware of it. Now, the dispute originated from Ukraine's 2014 decision to drastically increase rental fees for natural gas production from 28% to 55%. And JKX has, of course, instituted a number of different arbitrations, different proceedings, claiming that this increase could only have taken place through a change in the tax legislation, which was not followed by the governmental institutions. And having considered the case in a number of rounds, finally the Supreme Court has refused to enforce the emergency award. But I think it is of particular importance to understand the reasons why in this particular case this has taken place. The court has spoken about the public policy violation and the lack of proper Ukraine's notice and notification about the investment dispute. And I will touch first the last issue, so the notification about the investment dispute. Surprisingly enough, the JKX has sent a claim to the office of the president of Ukraine and not the Ministry of Justice. And why this has been done is still open. I assume this was more out of political reasons rather than legal reasons, but this was actually a big issue discussed. So make sure you do follow who's the proper respondent in your case. And this is, by the way, also very important in the enforcement stage. And I would always recommend at the outset of the arbitration, whether this is private or public arbitration, to think who is the proper respondent and how you will be enforcing the award afterwards, because we've seen a number of cases where a brilliant arbitration has been performed, unfortunately never enforced because it was conducted against the wrong party. At the same time, neither the Supreme Court nor any other court in this case has striked out the possibility to enforcing the emergency awards in principle in Ukraine. However, in this case, this was a rather straightforward issue that under the given facts in the case, this emergency award would not be enforced. Unfortunately, many questions remain open, and although the court has recognized that emergency awards should be enforceable under the New York Convention, still there is some tensions and some discussions whether this would be really the case in other cases. Now, I think to a greater extent, Olena has touched upon the cases which are publicly known. As you know, there is a high chance that we will never get to know about certain other cases under the ECT treaty, which are of course confidential, and there's no obligation to disclose them, which is a negative side for the arbitration community, not knowing much. But I think this is the rather positive issue for the both claimants and respondents, and one of the biggest pros of arbitration. The good thing about Ukraine's enforcement now is that we have the exclusive competence of Kyiv Appellate Court acting as the court which the enforcers, the applicants, approach directly. So this is already the second stage of courts in Ukraine. Before, this was not the case, and you would go to the regular district court, which considers from day to day all types of cases, family matters, labor issues, criminal matters, civil issues, and then there would be an enforcement of an award. So you can imagine that this would not be the proper way. Now the Kyiv Appellate Court acts as the court who has the exclusive competence for all matters related to recognition and enforcement of foreign arbitral awards. The good thing is that we have already a 2-month period for ordinary procedure for enforcement, which is a rather short period of time. Not necessarily is this always the case. However, normally you would have the award enforced or not enforced within the 2 months, or at least I would say 3-4 month period of time. We have sanctions of ungrounded appeals, so the misuse of procedural rights is recognized to be a ground for dismissing manifestly ungrounded appeals. So I think this is also a very, very good development. And we also have an accelerated procedure of 10 days in the cases where the recognition is requested by the debtor with this accelerated procedure. And basically, failure to appear in court would not be a barrier to recognition. We have now also seen a change in the calculation of interest. Interim measures are also possible. So I would say that Ukraine has made a good step ahead in the arbitration area. And out of formalistic reasons, of course, you would have to follow a certain procedure to file the original or a certified copy of the award, and the original certified copy of the arbitration agreement if we were speaking about private matters, power of attorneys, other authorizations, confirmation of the court fee payment, which are drastically low, copies of the application in accordance with the number of participants, and so on. So basically, there are no really hard matters to remember. As I said, however, a recommendation in private matters would be, of course, to think about the enforcement in the future. Ukraine as a country provides the money for enforcing the awards. The only problem is that the country may not really know the budget, how much will it own in the end of a certain year. So it may be the case that you come up with an award and you cannot enforce it because in a detailed account of the budget, there is no money left. But this does not mean that you will not get it. So normally it is transferred and to a next year, and then the government understands, okay, we have this award against us, and we will include a certain amount of money in the budget. So in the end of the day, the vast majority of all the investors who got the awards against Ukraine got paid. As we know from cases like Nogo, Yukos, or others, it is sometimes problematic when the country refuses to pay up. And thanks God, this is not against the case with regard to Ukraine. But I do believe that having all those very much professional colleagues today on the call, that basically we do need a certain development in terms of enforcement against the sovereigns who for many years do not pay the awards, because this actually undermines the existence of investor treaty arbitrations to a greater extent, and I do believe that some change has to be there. In the rest, I would say normally the enforcement against Ukraine would be quite straightforward. There may be appeal and cassation, because often the state entities simply say, we do not want any questions from any investigators asking why we did not appeal a certain decision. So you may as well be prepared for that. But in the end of the day, I do believe that a well-reasoned lawyer will be able to enforce an award. In private matters, in commercial arbitration, I would agree always still to pay attention on the proper notice. This is still the main guerrilla tactic used the parties who do not want to pay up their debts, and also making sure, I'll do a certain self-promotion, but for all Ukrainian lawyers, make sure to hire a Ukrainian lawyer from the outset of arbitration, not when you already have an award and come and say, we want to enforce this award. You may face certain issues you would not expect in other jurisdictions, and all Ukrainian lawyers be happy to assist you in that regard. And by this, I will conclude my speech for today, and we'll hand back the floor back to Natalia, who is moderating us today. And thank you, Natalia, for this.
Thank you, Mark-Jan. Thank you, everyone. We are coming to the end of this session, and I see that we have several questions here. I will read them up. The first question from Evgenia Rubinina. Would the fact that the making of investments under the Energy Charter Treaty is broadly defined protect against the standard chartered versus Tanzania interpretation of the requirement that investment be made? I think this is a question to Noah.
That's an excellent question. I mean, personally, this is my personal view. I don't agree with the standard chartered approach, even when the word "made" is included in the definition itself. But there is a division of cases. So there have been a number of cases where the argument was put to tribunals, and tribunals have said, no, there's no requirement to make an active contribution. So there's a split of opinion. But the question was put with respect to the broad definition. And that's a good question, because if, for example, within the definition, there were items which, are by definition passive assets, then you might say, well, that suggests that there's no requirement to make an active contribution. And one example of that is claims to money and claims to performance. If you have a contractual debt, how do you? Well, I suppose you could buy the debt, but that seems quite passive. Intellectual property, well, you could still acquire intellectual property. In any event, you could try to pull out of the definition an interpretative tool by saying, well, but look at some of these examples of investments. These are not things like a factory that you would build or acquire necessarily. There's more passive kinds of investment.
Thank you, Noah. Another question from Evgenia Rubinina, and I think the question is also to you. Arguably, a holding company can be said to acquire an existing investment under Article 1.8 of the Energy Charter Treaty. Unlike the Energy Charter Treaty, UK-Tanzania BIT did not define what it means to make an investment.
Yeah, that's true. That's true. I mean, if you look at this definition, as I say, I've never seen another definition of make an investment, right? And it's broad. It says means establishing new investments. Okay, with a holding company, we're not talking about that. Acquiring all or part of existing investments. Now, the question is, what's acquiring? Does acquiring mean any way it comes into your possession, you acquire it? Or is the suggestion that you're buying it? You could argue that both ways. You could say, well, it doesn't say buy, it just says acquire. But acquiring suggests some kind of exchange, right? Or moving into different fields of investment activity. Well, that would, you'd have to argue that, yeah, making an investment is so broad that so long as you have it, it's enough. I think the problem with that argument is the word make, like as a verb, it just has an inherent meaning. Right, and making is by definition something active. At least that's the argument that would be brought against you if you tried that approach. But I like the approach, Evgenia. Thanks.
Great. Another question, and this is the last one for the moment, from Evgeny Vasilchenko. In May 2020, the European Union signed an agreement terminating the intra-EU BITs. Should we expect similar decision in relation to the SCT? And if yes, is there any option to circumvent an SCT sunset clause?
I'm happy to address it. So like the most recent statement of the European Commission in that regard. So the reform of ESDS at the moment is not within that context, coming from that perspective of the validity of intra-EU BATs and dispute resolution mechanisms, is not on the table within the discussion of the modernization of the ECT, because the European Commission considers that discussions which are pending under the auspices of the United Nations within the Untitral Commission are the right fora to, to develop appropriate dispute resolution mechanisms, and we are talking about a court in this regard. Also, again, at the moment, European Commission is not taking the position that it would like to withdraw from this treaty, particularly in view of the sunset clause. Its preference is to actively engage into modernization negotiations to reach change of those provisions, considers necessary. Why? Because otherwise it will be left alone with unchanged provisions, and will be facing 20 years of application of the treaty in view of the sunset clause, which is comprised in Article 47.3, right, at the moment. So this is the direction which I see in the discussions coming from the European Commission. There was a very strong, for example, demand on the part of the European Parliament to withdraw from the ECT, because in view of the European Parliament, it's incompatible with the European Green Deal and the upcoming transition to the low carbon economy.
And Natalia, I can just add, with respect to avoiding the sunset clause, it is theoretically possible. That's what the European states have done with respect to the BITs between them. They've cleverly gone and, before terminating intra-EU bilateral treaties, they've amended them first to excise, to cut out the sunset clause, and then they terminate it by mutual consent, and that kills the sunset clause. Now, with the ECT, that would be super tricky, because you'd have to get every single state of the Energy Charter, every single signatory, to let the European Union off the hook. If I were advising the other states besides the EU, I'd say no way. But after all, but you could imagine a partial modification of the ECT, where all the states would get together and would allow the EU member states of the ECT to modify or eliminate the sunset clause with respect to them, as between them, with no effect on everyone else, but with everyone else's consent. And so essentially you'd say sunset clause applies except with respect to disputes between or investments by EU member states against, in other EU member states or something like that. So it could be done. It seems a pretty complicated exercise. And if you get that far, you could probably do even more dramatic things to the Energy Charter Treaty that would achieve the same result without actually taking the European Union states out of the ECT altogether, which clearly they would prefer not to do, because they get other benefits from it.
Well, it's clear that pretty interesting times are ahead of us, actually. We will see how this is going to work and which mechanism will apply or will be invented in the future in relations between the European Union and the Energy Charter Treaty. We received while you were speaking, we received a comment from the audience. Yuri Почтовых. Evgenia's interpretation of Section 1.8 is shared by the Isolux Tribunal. Others, for instance, Park in Alapli Peliu Energo Alliance, opined that the investments must have been made by the claimants themselves. So I see that this is not a question, but rather a comment. And since we do not have any further questions from the audience, I conclude that we have come to the end of our panel. And I address now all the participants, and would you please all join me in thanking our really excellent panel, Olga Hamama, Noah Rubens, Elena Perepelinska, and Markian Malski. Thank you everyone for participating. Stay safe and see you soon, hopefully in real life. Thank you.
Thank you very much.
Thank you.
Thank
Bye.
you.
Thank you.
Bye.
Thank you. Bye.